Hi everyone, welcome to the third of our conversation series in managing disruption in supply contracts. So we've had a particular eye to the current disruption being caused by the COVID pandemic. So with that in mind, today we're going to look at two really important remedies in a supply agreement. If you've been experiencing disruption, we're going to look at termination, and also we're going to have a look at liability and the types of limitations and exclusions you might see in a contract.
Thanks, Claire. This is where it can get quite serious, isn't it? And where legal disputes become a real possibility. We hope that by getting to know how termination clauses and liability clauses work, you can hopefully avoid any legal dispute. So let's get on with it, Claire, and we'll take each clause in turn if we can. So I'll start with a very simple but important question. What does a termination clause do?
So, Bryn, basically it brings a contract to an end. Usually in a contract, you'll have a termination clause that will require you to give notice, perhaps, certain number of days notice in writing. There are also various other ways a contract can come to an end as well that are not termination. The obvious ones being the expiry of the contract or the performance has been completed. But we're not going to focus on that today.
Good. Okay, we're going to keep it simple. That's always what I want to hear. So I know that a contract can give a party a right to terminate, but also that the law sometimes gives the party a right to terminate a contract. So first of all, when does the law allow a party to terminate a contract?
Right, Bryn. So basically, by law, if there is a breach that goes to the heart of the contract, so we can say it's a mega breach, you're expecting to be paid, you don't get paid, then the technical term for that is a repudiatory breach, and that means the parties have got a right to terminate. There's also one where a party just sits on their hands and they refuse in advance to perform an obligation. So a supplier telling you that they're going to withhold payments that you're obliged to make.
Okay, good. Sorry, I was just reminding myself that mega breach actually isn't the correct term.
It's not a technical term.
Remember that. Okay, good. Okay, so that's good to know because it means that the law puts these protections in even into an implied contract or an oral contract. So that's good to know. But moving on to contractual grounds for termination, and these will usually be the ones relied on. What are the typical grounds for termination you'll find specified by a contract?
Well, again, in simple terms, I break it down between what I'd call a fault termination, something's gone wrong, and no fault. So a no fault termination right might just be a termination right for convenience. Customers like this, they can just decide after a certain period of time they don't want to get out of the contract. From a supplier's point of view, you're not going to like that so much because you're not necessarily going to get the income that you've banked, let's say, for your 2 or 3 year contract. So you want to be thinking about any cost implications of that. The other one, which I talked about in the last in the last conversation, was around force majeure and there being a termination right if there's a continuing force majeure event. So that's no fault termination. In terms of fault, it's really when things go wrong. So there's a failure to pay, obviously the key one for the supplier, or there's breach. So you can typically see what we would call termination for material breach, where you have a certain number of days to remedy, and then there's a notice period, and then the customer can terminate, or it can be either party. And the other typical one you might see is what we call persistent service level breach, where you've got service levels and there might be a particular threshold that just says the service is lousy, and that gives the customer the right to get out of it. I think to finish off though, in a contract, you can choose any event you want to put in as a right to terminate, because there could be, for example, the IP could be particularly, breaching IP rights might be particularly important. So you might want to terminate for that. So kind of always look through the contract because they might not be in the same place at the different rights and when you might want to leave a contract. And I think finally, be careful, because if you're giving a notice of termination when you don't actually have the right to, that actually can be a breach itself.
Yeah, thank you for that. One thing that you'll often see looking through a contract is a section headed consequences of termination. So what are the typical legal and also contractual consequences when a party terminates?
So again, it will depend. Some contracts written on the back of purchase orders might not cover anything at all. But I would say typically at the end of the contract, you're downing tools, parties might want to take back the confidential information that they exchanged. You kind of want to check where the licenses for IP come to the end of a contract. Then there's a few sort of commercial practicalities. Are outstanding orders going to be fulfilled? Are there any payments that need to be made? And then I'd also just check whether there's any ongoing obligations or restrictions that might apply after termination. So always plenty to look out for, and really to be cost conscious about that, and to sort of see what extra costs might apply if a contract comes to an end.
So thank you, Claire, for that a pretty full run through of the situations where a party might terminate. It wasn't quite full, of course, because we have left out one situation where a party might terminate, and that is where the other party is or is likely to enter insolvency. Now, we're very lucky to have Jess Boxford with us. She's a colleague of ours from the dispute resolution team. And Jess is here to talk to us about when a party can terminate for insolvency and some recent changes to the law in that area regarding suppliers. So Jess, could you just take us through when a party can terminate for insolvency, and also the recent changes in relation to suppliers?
Yeah, thanks, Bryn, and thanks very much, Claire, for that run through. So it is typical to see in a contract the ability of a supplier to cease supply when their customer becomes insolvent or enters an insolvency procedure like administration or liquidation. However, the ability of contracting parties to terminate in those circumstances has been changed this year by new legislation. Suppliers can no longer make use of contractual termination provision, which allows termination on insolvency where a customer has become subject to insolvency procedure. So the legislation actually goes further still. If the supplier had a right to terminate before entering into the insolvency, before the customer had entered into this insolvency procedure, for example, the customer hadn't been paying, or there'd been another material breach of the nature that Claire's discussed, but the supplier hasn't used that right to terminate, its ability to then use that right to terminate once the company or the customer has gone into insolvency has been lost. So the supplier would then find themselves in a situation of having no choice but to continue supply, despite possibly facing a backlog of unpaid invoices. Before the new legislation came into force, there were some limited restrictions on the ability of suppliers to terminate contracts where customers have become insolvent, but that was limited to suppliers of essential services. The new restriction is now a blanket restriction on all suppliers of goods and services.
So this is sounding like potentially quite restrictive on suppliers. Does the new Act provide any exceptions that a supplier might take advantage of?
Yeah, there are a couple of limited exceptions. If the insolvency office holder who's been appointed over the customer consents to you terminating, then you can, between the supplier and the insolvency office holder, you can agree that you'll terminate the contract. That's likely in a situation where the insolvency officer has been appointed and they're not going to trade on the business, so they have no ongoing need for your goods and services. Alternatively, if you can't get the insolvency office holder to consent, you can apply to the court. You'd need to satisfy the court that in continuing the contract, you're going to suffer hardship, and then the court may grant you permission to terminate. But of course, the problem with that is that you've got to go through the expense of applying to court to benefit from that exception. As a result of the pandemic, there is also a temporary exception that if you are a small entity, so if you, the supplier, have a turnover of less than about 10 million and fewer than 50 employees, you may also be able to benefit from an exception to the new rules. And one last point that's worth making is it's not clear yet whether if you're a supplier overseas, whether this new act will apply to you or whether you can actually terminate as you would have done before.
Okay, thanks, Jess. So I think that gives me an idea of what the law says. Obviously, what we try to do is to help our clients navigate the law and protect their interests. So is there anything suppliers can do to avoid getting stuck without the right to terminate an agreement that's come to an end, or simply as a bad bargain?
Yeah, so there is a little bit, Bryn. There's a few things that suppliers can consider. Firstly, the restriction on termination only applies when the customer has actually entered into an insolvency procedure. So if there's rumours around a customer, or you have concerns about they're not paying their bills, the supplier should try to monitor that customer's financial position, find out what they can, because if there's likelihood of insolvency coming very soon, then a supplier can take the decision at that stage before the company enters into an insolvency procedure to terminate. They'll still have their rights of termination, even if the customer is actually what we call cash flow insolvent, but not yet in an insolvency proceeding. You can still terminate in those circumstances. So for suppliers, it's a case of keeping a very close eye on customers that aren't paying and finding out what they can. And then there's the consideration of going forward when suppliers are entering into new contracts. Consider what they can get into those contracts that would allow them early insight into a customer's financial situation, so that rather than having to monitor that and find out the information themselves, they can ask the customer to provide, and the customer has to provide, if they agree, that financial information, which will give the supplier the information they need early enough to make the decision quickly enough.
Okay, thanks, Jess, for taking us through that. Please do stay there, because we'll be coming back to you later in the chat. But that takes us through, I think, the main different circumstances where a party might want to terminate a contract. The other clause that we're going to be talking about, as Claire mentioned, is liability. This is the remedy that a party might be able to claim to cover any financial loss that they've suffered due to breach by the other party, i.e. damages. So, Claire, if we move on to this, could you just explain briefly how termination and damages fit together?
Yes, definitely. And although I'm itching to get stuck in with this, I thought I would just mention one thing from what Jess mentioned, that actually we often like to see quite good governance procedures in contracts where the party just might agree to have regular meetings and reporting. And really, if you're kind of having that in the contract and that intention to kind of interact and have quite open communication with your customers, then often these sorts of issues, like if there's problems with, becoming likely to become insolvent, are going to get flushed out early. So I just wanted to mention that. But to come back to your question about termination and damages, the first thing to say is they're separate remedies. So there are different triggers for the right to terminate. And what we want to say about damages is this is really just to do with the fact that there has been a breach of contract, and the party who's been subjected to the breach, they've suffered losses. So they're going to want to recover them in some way. The one relationship I would put is if there's a fault termination, like, you're terminating because the service is just rubbish or you're not being paid, then clearly at that point, it's quite likely that you might have had to go elsewhere to find a service from another supplier, and you're going to have suffered losses and want to recover them. I think the final thing to say is that really, you're normally only going to look to recover your losses when the relationship is broken down and you're looking to terminate for breach. But I would certainly say, in my experience, that's not always the case. And actually often, and the parties can identify the fact that they've suffered losses and incurred costs and can sort of seek to resolve them, even though they stay in the contract.
So, as you're saying, losses can potentially be payable as damages, but how does a party go about finding out what their potential exposure is? How do they find out what their liability is under a particular contract?
Sure. So this is really about how much you can financially recover if you've incurred costs because of a breach. So the contract might be silent, or you might have an implied contract, in which case you're going to rely on the not completely uncomplex rules of English case law to guide you through what losses you can recover. But then otherwise, hopefully, you're looking at a clause in a contract that's going to have liability in bold, that's going to set out some of those parameters, what kind of limits or exclusions and what you might be able to recover by law.
Okay, so I'm just very briefly going to ask you to touch on those joys of English case law. So obviously the law does limit recovery in the form of damages. So can you just briefly tell us what the sort of headline limitations are on recovery of damages?
Yes, of course. So the main aim really is to put the affected party back in the position as if the contract had been performed. So clearly, if they're kind of incurring costs because of it, they want to recover them. But it's not just all losses. Can you imagine how expensive a contract could be where you're looking to recover all your losses? There's sort of two key English law limitations worth mentioning. One is about mitigating loss. So as a customer, if a supplier fails to provide goods and you go and look for somebody else, you need to do that at a reasonable cost. You can't just sort of let the losses hit you. The other kind of technical legal term to mention is what we call remoteness of damage. And all that means is that that damage, the loss, just needs to be reasonably foreseeable, to have been contemplated. It can't be something completely, something that the parties would have been completely unaware of at the time they entered into the contract.
Okay, so that gives me an idea of limitations imposed by law on recoverable loss. But I understand too that a contract might expressly limit or exclude a party's liability under that contract. So first of all, what is the difference between an exclusion of liability and a limitation on liability?
So yes, to an important question. Exclusions are really setting out what types of losses you're not going to be liable for. So again, I think it's really common to see exclusions for indirect and consequential loss of profit. Those kinds of things are really typical, but really check those clauses, because often, let's say a supplier might sneak in loss of data. And that's not going to be very helpful to you as a customer if you're providing data to your supplier. You don't want that to be excluded. So it's always worth reading the fine print. Limits, however, just put a financial cap on the liability and any losses the party can claim.
Okay, and what is a typical liability cap in a supply agreement?
So just we want to remember that this conversation about liability can sound very legal and technical, but this is all around the balance and making sure that you've struck a good bargain in your contract. You're always balancing the benefit of the service you're buying, for example, and then the risk you're prepared to take. So it's just really common to cap to, let's say, the fees paid under the contract or a specified amount. But always kind of take a look. There might be different liability caps. There could be areas of greater sensitivity or clauses that are completely excluded. So it's always worth, again, really checking the contract to kind of understand what those parameters for your liability are and check it feels proportionate to you.
So it sounds obviously like liability caps can be very important to protect a party's exposure to liability, but obviously they won't work unless they are enforceable potentially by a court. So what do you need to do to make sure a liability cap is enforceable? Are there any losses that can't be limited by law?
So I'm just going to mention two key areas to kind of keep everybody awake while they're listening to our discussion about liability. You can't exclude death and personal injury caused by negligence. You can't exclude fraud. And then just don't forget, under consumer law, actually, you can't put a liability cap in. And if you do, it's going to be unenforceable. So I think those are the kind of 2 or 3 key takeaways in terms of what you can't exclude.
Thank you, Claire. Yeah, there is more to be said on that, isn't there? But
yeah,
perhaps a later conversation. So just one other quick thing to bring up. We always look out for indemnities that might bind our clients. Can you just briefly explain to us what an indemnity is and also whether liability under an indemnity can be limited?
Yes, definitely. When I first started out as a lawyer, the first thing I was always told to check in a contract to protect my client is to kind of look out for those indemnities. And the reason for that is if it's an indemnity, it's a bit like the repayment of a debt. So if a certain event occurs, there's a pound for pound recovery. So all those parameters I just talked about don't apply. So again, the risk for the client can go through the roof. because there isn't those kind of rules around mitigation that I just talked about. But again, you need to read your contract. Indemnities are often incorrectly drafted. They're not always enforceable. And sometimes you get an indemnity, for example, under a different jurisdiction like US law, and then it's capped. So always kind of read through the document and kind of check about those indemnities and how they fit into the overall picture.
Well, thank you, Claire. I think you've very ably given us the commercial lawyer's perspective on termination and liability. We obviously do have Jess here. I hope Jess is still with us, who is able to give us a dispute resolution sort of expert take on this. So, Jess, is there anything you'd like to add to what Claire has been telling us?
Yeah, thanks, Bryn. I'm certainly still here, and really, it's really good to hear all of the things that Claire has had to say. And I think it's for our clients listening to this, those are the really important takeaway points. To know your rights. You need to know your rights under the contract. But please think twice before jumping into a situation where the court will be left to decide who gets what and what your rights are. As a disputes lawyer, I always say it will always be quicker and cheaper to first try and resolve any disputes by talking and negotiating an outcome that suits both parties. A negotiated settlement will require both parties to feel like they've given something up. It's often said that a good settlement requires both parties to feel like they've given too much up. That's when you know you've hit a good balance. But the real upside to negotiating a settlement is that you remain in control of the process. Until the settlement is finalised, you're always able to threaten legal proceedings or indeed commence legal proceedings if you want to leverage your position. But parties should consider that litigation and arbitration should be a final step if all other avenues to settle have been exhausted. Formal legal proceedings are expensive and time-consuming. They're time-consuming both in terms of the time taken until you get to a resolution and the amount of management time involved in preparing the case. And ultimately, the result is unpredictable. You, the parties, the customer and the supplier, you know most about this. You're in the best position to get to a good outcome. When you go to court or arbitration, you're handing all of that power over to a judge who just, has a snapshot of the information. And the other great upside to negotiating a settlement is that it can and does preserve an ongoing relationship. So often a customer and supplier have put in a lot of time and effort with one another to have their relationship. And if you can negotiate a settlement where both parties walk away perhaps feeling a bit bruised, you still may come back to each other. Whereas if you enter into legal proceedings, that's probably highly unlikely.
Thanks, Jess. I mean, that really recaps something that Claire and I have consistently touched upon in this mini-series, that a negotiated resolution is almost always the best option. So thank you very much, Jess, for joining us today. Claire, just for one last time, I'm going to ask if you could please just recap and put in a nutshell the conversation we've had, and just give a summary, please.
Yes, definitely. So first of all, look out for your different termination rights and those notice periods. Make sure you're exercising them correctly. Be clear on the consequences of termination and any continuing obligations. When it comes to liability, just check you're getting that right balance of risk and benefit, and don't have any sneaky indemnities or clauses that kind of cut across a liability cap, you might agree. And I think finally, again, following up on what Jess said, try to negotiate an outcome amicably. It's not just that you could save time and money, but if you can weather hard times, particularly like the hard times we're in at the moment, then that could really strengthen the relationship going forward. Okay, so thanks to Bryn and Jess, and thanks to you all for listening. We hope you found it helpful. So that's the end of this series, but don't worry, we're going to have more conversations in the pipeline soon. We're thinking about diving into some more detail about some specialist clauses that you can see in a contract, like IP and employment. But it would be great to have your suggestions. And of course, if you have any questions, just get in touch.